Good morning, everyone. It's me, Lauren Cadilac, aka OG Cadillac from Dallas, Texas. I'm so excited to talk about what an appeal is, types of appeals, and so on. Okay, so as I have told you, I am a civil attorney. That means I do my work in civil court. We have been watching together the Young Thug RICO trial, which is a criminal case being handled in criminal court. And so I'm sure you can imagine that there are different burdens of proof and different rules of procedure for both civil and criminal law. Okay, so my familiarity with these things is typically, my practice has been in the civil courtroom. However, the exciting appeals, and I think the appeals that really are impactful to American public, come out of criminal courts typically. Okay, so there are types of appeals, but an appeal in itself is a request to the appeals court, which is a higher court than a trial court, to make a ruling about something the trial court has done. Sometimes it's to make a ruling about something the prosecution has done, but typically the role of the appeals court is to see the rulings the judge has made and determine if those are correct or not. In order to have that appeal, then there must be error on the part of the trial court judge. So if you go through, a trial court judge does not make one single error, then nothing is appealable. You can't appeal. There's no appeal. You can't appeal just because you don't like the result. All right. So if you lose your civil lawsuit, you can't appeal simply because you lost. You can only appeal because there is some kind of mistake the trial court judge caused that made you lose. All right. In Texas, where I am licensed to practice law, there are some issues that go to the appeals court on final judgment and some that go in interlocutory appeal during the course of the trial. And we'll get into that in a little further. But in order to get into a courtroom, the court must have jurisdiction. So in criminal cases, the court that has jurisdiction is the county where the criminal violations occurred, okay? In civil cases, it's a little different. There are financial standards depending on the different courts, which court the appeal goes to, depending on which court it came out of, and if the court is the proper jurisdiction. So an example of when there is an improper jurisdiction, I do real estate. So the code, the Texas law says that real property issues in a county are heard in that county's district court. So when I sue related to a piece of property in that county, I sue in that court. Well, one time I had a case where it's about real property, but my client signed some documents with a banker out of California. And in those documents, it said that the jurisdiction and venue would be California. So my argument was that while you can agree to different venues and jurisdictions, the court of original jurisdiction, as in the only court that can hear matters related to real property in Dallas County, is the Dallas County District Court. We ended up settling before the judge made the ruling on that. I really wish I knew what he was going to rule, but we ended up settling the case before that. If the judge had ruled that I was correct, the case would just go forward. If the judge had ruled that, in fact, you can sign an agreement and change the jurisdiction, then my client would have had to go to California with their lawsuit. But that seems so weird to me because it's about real property in Dallas. That just didn't seem even appropriate. There are also different jurisdictional issues, like in federal court, you have to have at least $75,000 worth of damages, and there's a lot of rules about when it's multiple states, etc. So those jurisdictional issues, when a court makes a ruling that they do not have jurisdiction, that is a final ruling. The court is saying, I'm not allowed to make choices about this case. And the only way to combat that is through an appeal. There are other types of rulings where you can't even combat them through an appeal. And the reason for that is because a lot of weight is given to the trial court judge in the idea that the trial court judge has made the correct decision. The appeals court judges usually come from a trial court, all right? And we are all attorneys here. We've all gone to law school. We've all passed the bar exam. So great deference is given to that trial court judge. All right, so I started looking for clips out of the Texas Criminal Court of Appeals, and I found some for you guys. This one really has to do mainly with the deference to the court, the scene I'm going to tell you about. And there are a bunch of lawyers in this particular appeal. My understanding is, in this case, a judge, he did sentence stacking, and it is unclear based off the rules of the courts of if he did that right or if that was allowed. My understanding is that sentence stacking is if you have some old crimes and now you've got some new crimes, can they stack sentences? Can they combine crimes? I'm not fully sure. So the court is now going to hear a discussion about that and what happened in this sentence stacking. Basically, the guy had possession of a controlled substance. He's a drug addict.
Good morning, and may it please the court. I'm John Messinger, Assistant State Prosecuting Attorney on this case out of Hood County. Article 4208 says that a trial court has discretion to stack a new sentence on top of an old sentence. The statute doesn't say anything about the specificity that has to be in the judgment. It doesn't say that there's any fact-finding that needs to be done. And in fact, this court has made it clear that there is no fact-finding, that it's entirely a normative decision. And that
okay, I'm going to stop you here. These lights, this green light means he can go. It's his turn to talk. The yellow is going to be a time warning, and then the red means you're done. Because in the appeals court, your oral argument is limited to a certain time period. Your pleadings usually, or your appeal, is going to be a really long document, really long.
The lawful accumulation order is unassailable on appeal, yet this court sanctions the assailing of multiple stacking orders for various reasons. One of them is for lack of an unspecified level of specificity in the judgment, and also for having inadequate record proof to show that the defendant does in fact have a prior conviction. This is not a new issue. This court's granted review of this issue.
Okay, so basically this guy is saying, look, this court has had several decisions about how these things should take place. And so now we're in front of you asking for just an actual decision. And then the other two lawyers, they get up and they kind of ask for the same thing. They really just want to know, is this allowed? And if it's allowed, how should it be done? And so what will happen is the appeals court will consider their arguments, and then they'll make a ruling. And typically, if they think the trial court did it wrong, they will do what we call remand to the trial court. Basically, hey, you did this wrong, take it back and go do it right. Kind of like having a paper edited. All right. The type of appeal we were just talking about is based off of a final judgment, right? That's when the jurisdiction's been disposed of, a jury has made a decision, etc. But there is another type of appeal where there is not a final decision, but what we call a dispositive decision. Basically, this would be, let's say, a motion to exclude evidence, and the judge rules in favor and excludes a bunch of evidence. Now, we are still going to trial. We don't have our jury's verdict. We don't have our judge's judgment. We just have this evidence we're now no longer allowed to use. What we could do then is file what's called an interlocutory appeal. So now it's interlocutory because the trial's still pending. They're not even in front of the jury. When the appeals court comes back with their ruling, they're either going to conclude that the exclusion is appropriate, or they're going to say it wasn't. If they say it wasn't, they'll remand it to the judge. If they say it was appropriate, prosecution could then try to go to the Supreme Court to get it entered, but if that's probably pretty unlikely. Another type of appeal. So we've talked about final judgment appeal. We just talked about interlocutory appeal. There is a third type of appeal, which is an appeal de novo. DENOVO. In my mind, the way language logic works for me, that means of new, de novo. I don't know why, but it is a new trial. So here in Texas, let's say you're a landlord and you need to evict someone. You go to JP court, Justice of the Peace Court, and you do your eviction, okay? The Justices of Peace is original jurisdiction for possession of real property in Texas. So you go to the JP court, you file your eviction, you win, your tenant appeals, okay? The tenant has a de novo appeal at the county court. And what that means is if the first trial never happened, de novo is brand new. So now when your tenant is going to the county court on a JP appeal, you redo everything you did at the JP court. That was my best example. All right, you can appeal against an order granting a new trial. So in Texas law, if we lose a trial, we must first ask for a new trial. We first say, hey judge, thank you for hosting the trial. There were a couple of mistakes that we think were made, and we would like for another opportunity where maybe you don't make those mistakes. If the judge says, okay, you know what, you're right, I did make a few mistakes, let's redo it, then the other party would do an appeal and say, no, that's bullshit. What are the results when an appeal occurs? Well, we talked about one a few minutes ago, remand. That is when the appeal court hands the case back to the lower court and says, you are now remanded to follow this rule and move forward. Okay? Then that is the result. They go back and they redo it following the appeals court's rule. In Texas law, under Article 44.04, when a defendant's conviction is reversed by a court of appeals, the defendant is entitled to reasonable bail pending a final determination of the appeal. Sometimes the appeal can be remanded, sent back to the court, and then there be another appeal arise from the next session of court. People are humans and humans make errors. And so because of that, that's why we have the appeal system, right? That is why we allow people to say, no, the judge was wrong. This should be redone and decided differently. Okay.